On Wednesday, a federal appeals court blocked a California law that requires federal immigration officers to wear identification. There have been several states pushing back against the Trump administration's immigration enforcement. Washington is one of them. To dig into this decision more and how it could impact a new law in our state, we're joined by Gonzaga law professor Erica Goldberg. Thank you for being here, Erica.
Thanks for having me.
Why did this appeals court block this California law?
Sure. So I'm pretty sympathetic to why California, Washington want these laws to make sure that federal law enforcement and state law enforcement are identified. But the problem is, regardless of kind of the political push for something, we have fundamental rights and structures in the Constitution that say that the states can't tell the federal government how to conduct its law enforcement operations. So this was basically, these preliminary injunctions were based on the Supremacy Clause, which says that federal law is supreme over state law. So any state laws that tell the federal law enforcement how to do their jobs are going to be suspect.
Well, we've seen the federal government repeatedly say these state laws do not have authority over federal agencies. So is this legislation essentially toothless?
Yeah, basically, right now we have the Ninth Circuit Court of Appeals, which is the Court of Appeals that sets precedent for both the state of Washington and the state of California, issue preliminary injunctions. So these are not final rulings, but what they said is the United States is likely to win on the merits, meaning a federal Court of Appeals has already weighed in saying that these laws are invalid, unconstitutional, or they're likely to be considered invalid and unconstitutional.
Well, last month, Governor Bob Ferguson signed a law banning most law enforcement officers, including federal officers, from wearing face coverings. Could that ruling impact our law?
Yeah, in fact, the Ninth Circuit, besides saying that probably California cannot enforce its ID requirements, a few months ago also said that the California law banning face coverings, except in certain circumstances, was also likely to be unconstitutional. Basically, anything where a state is telling the federal government directly how to conduct its law enforcement operations is going to violate the Supremacy Clause.
In your professional opinion, do you think the California case could end up at the Supreme Court?
I'm not sure. You know, this was a unanimous panel of the Ninth Circuit, meaning it wasn't political. It was almost like a pretty easy case. I think if we found a harder case, maybe a gray area where California was trying to kind of massage how federal officers comport themselves, but wasn't directly instructing them on what to do, maybe that could go to the Supreme Court. And maybe just because it's an issue of such national importance, it'll end up at the Supreme Court. But right now, I think that, you know, the unanimous panel with 2 Trump appointees and 1 Obama appointee makes it seem like at least the Constitution is pretty clear that the states can't do this.
Erica Goldberg, thank you for your time.
Thank you.